The Second Amendment was a safeguard against the militia, and the Third Amendment with its prohibition on quartering of soldiers in times of peace. What does this have anything to do with Trump's activation of the National Guard? Is she proposing that the Antifa should be arming themselves and shooting and killing our National Guard? Is it Second Amendment time, Judge Perry? If not, why are you raising the Second Amendment? And is Trump proposing to quarter the National Guard in private property? Is that what you think is happening? That's why you're raising the Third Amendment? It's insane. Minus 10 points on this exam. The origins of 12406. This is the decisive legal question here. The final piece of our historical puzzle. Again, she got through all the history. She's done the entire historical puzzle except for this final piece. Never mentioned the Whiskey Rebellion. Never mentioned the activation of the National Guard during the 60s for school integration purposes. Never mentioned any of them. She mentioned not one prior activation of the National Guard by a president. But she's arrived at the final piece of the historical puzzle. Unbelievable. 12406 reads, and it has three provisions that are of interest to us. The first involves invasion by a foreign country. We're not talking about that. The second is if there's a rebellion or danger of rebellion against the government. And the third is the president's unable with the regular forces to enforce the law, execute the law. These are the two big ones that authorized Trump's activation of the National Guard here. The key provisions of 12406 originate with the Dick Act and the Militia Act of 1908. We can overlook much of this history. Nothing really changes. She goes over a lot of this because she's trying to argue that the Dick Act, which no one's ever heard of. My 34 years of practicing law, I never heard of the Dick Act. Probably because it was passed in 1903, and within 5 years it was replaced by the Militia Act of 1908. What she's doing here is she's building the nonsensical argument that regular forces in 12406, regular forces here, means the active service, Army, Navy, Air Force, Marines, Coast Guard, and I left off Space Force before. This is where she's trying to build the ridiculous foundation that the President of the United States, although this has never been done this way before in the entire 249 years of America's history, that the President of the United States is not permitted to activate the National Guard under this provision unless first the entirety of America's active service military forces were insufficient. She's going to find the regular forces that have to have failed to execute the laws as our standing active service military. And she does this with a torturous reading of the Dick Act and the Militia Act of 1908. Legal standard. So these are the requirements to get a TRO. We've gone over this 100 times. There's 4 of them. When the government's a defendant, there's really only 3 because the first 2 will combine. But the only one that really matters for our purposes is a likelihood of success on the merits. That Illinois and Chicago get this TRO if they can show they're likely to win on the merits, that Trump does not have the authority to activate the National Guard here, that he's outside the bounds of 12406. The rest of it we can skip over, because if that one fails for Chicago and Illinois, they can't get a TRO. Chicago and Illinois allege that Trump has violated 12406 and the 10th Amendment and the Posse Comitatus Act. Again, the 10th Amendment argument and the Posse Comitatus argument fail if Trump is authorized under 12406. And for her to find that he's not authorized under 12406, we're going to see how torturous her arguments have to get. So I'm really going to focus on the 12406 argument here. Defendants challenge plaintiffs to president standing. Trump challenges Illinois and Chicago's standing to get a temporary restraining order on the grounds that he's violated 12406. And again, she engages in circular reasoning here. I'm not going to spend a lot of time on this because what she says is, well, she begs the question. She says Trump is violating 12406, therefore he's acting unlawfully, and Chicago and Illinois have standing to object to an unlawful act by the president. But of course, that's completely circular reasoning. If Trump is authorized under 12406, then he's not acting unlawfully. He's acting lawfully. And Chicago and Illinois have no legal standing to object to the president acting lawfully. It's just insane. So I'm going to skip over all this nonsense in the interest of time. Oh, let me see if there's anything worth mentioning here. She has to deal with this case. This is a Supreme Court case, Martin v. Mott, from 1827. And this is a case where the President Madison called out the New York militia during the War of 1812, and a militiaman refused to report for duty. And he said that's because, although President Madison believed the conditions for calling out the militia had been met, he disagreed. Jacob Mott had a different opinion than the president. And he should be allowed to challenge the president's commander-in-chief position in court. And then a judge, an unelected black-robed tyrannical inferior district trial court judge, should get to decide. The judge should get to decide if Madison's view of events should hold, or if the view of the militiaman who didn't want to report for service should hold. And what the Supreme Court said was that this is entirely within the discretion of the president. The Supreme Court held, she has to cite this because it's so obvious in the case. The Supreme Court held that whether the president's authority to call for the militia had been properly invoked, whether the exigency of the circumstances had in fact arisen, was an issue to be decided solely by the president and not subject to be contested by every militiaman who shall refuse to obey the orders of the president. But what she says here is, well, the facts in Martin were different. The facts were different than here because this involves Antifa and that involved the War of 1812, and therefore I don't feel obligated to apply the Supreme Court precedent from that case to these events, which is not how precedent works, folks. The precedent is always different in some facet. It's never the exactly identical case. What you're applying when you apply precedent is the underlying legal principle. And the underlying legal principle is that these decisions, whether the exigency has actually been met that allows for the activation of the guard has arisen, is decided solely by the president. But of course, she doesn't like that answer because that would oblige her to reject the TRO. She says, well, Martin involved an invasion. And therefore, well, maybe in an invasion, it's entirely up to the discretion of the president, but we're not dealing with an invasion here. We're not dealing with an invasion. So if it's by the way, the statute doesn't say anything like this. The statute doesn't say if it's an invasion, it's up to the president. But if he can't enforce the laws or if there's a rebellion, then it's not. Then a judge gets to decide. The statute doesn't say. It just sets these three conditions. Alternative conditions, any one of which allows the president. And Martin v. Mott involved an invasion. The first alternative condition for activating the National Guard by the president, and the Supreme Court said, well, the president says there was an invasion, we're going to defer to his discretion. Why would that same discretion not apply for reasons 2 and 3 in the same statute, unless the statute says otherwise? Which it does not. Finally, in the 200 years of judicial review jurisprudence since Martin, the Supreme Court has provided ample guidance for when the political question doctrine should or should not apply. So, again, she's talking about the political question doctrine. And that holds that when something is purely a political question, then it's not up to the apolitical Article 3 judges to decide what the policy should be. Nobody here is arguing the political question doctrine. Trump's not arguing it. Illinois is not arguing it. Chicago is not arguing it. She just, like a bad law school student who doesn't know the right answer on the exam, she's throwing in additional bullshit to fill in the number of pages required. Even she only gets a paragraph out of it. Pathetic. All right, likelihood of success on the merits. This is the only real condition for the TRO that matters, and the only real argument is 12406. Again, 12406. If there's allows the president to call forth the National Guard, if there's a foreign invasion, we're not dealing with that. Rebellion or danger of rebellion. Is Antifa, are these protests, the violence, the property damage, is this not to impede, frustrate the federal government's exercise of its lawful immigration authority? That is a rebellion against the immigration authority of the United States. That is incontestable. But she's going to get around that by saying, yeah, but it's only a rebellion against just the immigration authority of the United States. It's not a rebellion against the entirety of the United States. They're not trying to overthrow the Senate. They're not trying to burn down the Supreme Court. They're not trying to kill IRS agents. They're only trying to kill ICE agents. And that's not enough to qualify as a rebellion, even though every prior use of the National Guard by a U.S. president to put down a rebellion was a rebellion against one narrow facet of federal law. Whiskey taxes in the Whiskey Rebellion, school integration, in the case of the 1960s activation of the National Guard. By the way, another BS argument that I hear the left making now is, well, in the 1960s, the school desegregation case, that was the result of a court order. So the president was allowed to activate the National Guard to enforce a court order. How can anyone who's not a moron think the president would have the authority to activate the National Guard to enforce the order of a mere unelected black-robed tyrannical inferior district trial court judge, but not to enforce the authority of the federal government under the U.S. Constitution? And by the way, the Whiskey Rebellion did not involve a court order, and Washington had no trouble activating the National Guard and leading it personally into combat. Is that what Trump needs to do here? Put on a George Washington outfit and get on a horse and ride into Chicago? So the two conditions that matter here are if there's a rebellion or danger of rebellion, or the president's unable with the regular forces to execute the laws of the United States. And she deals with this one by saying, well, he's not completely unable. If he's able to execute the laws one time out of a million, well, then he's able to do it. He's able to do it. Unable to enforce the laws means he tries a million times and he can't even do it once. And she'll say the regular forces means the active military. Trump is supposed to have to send in the active service Army, Navy, Air Force, Marines, Coast Guard, Space Forces, and only if they fail is he allowed to call up the National Guard. So she wants to interpret stuff. Let's get to her crazy interpretations. Before the meaning of Section 1206 subsections, a note on deference. Trump is not entitled to deference on what constitutes a rebellion or what it means to be unable with the regular forces to execute the laws. She's saying this because she's going to interpret these things in the torturous ways I just described. But she says, once I create my torturous definitions, well, then I'll give the president deference on the question of whether the facts meet my torturous definition, which, of course, she's defined her definitions to not do that. I have a lengthy list. Did I save it? That'll have to be good enough because I can't find it. She doesn't remember all these other instances sending the National Guard for riots, even when governors fought them, including, of course, Arkansas. Let's see. I think I have that image handy. Is this it? Yep. This is Eisenhower's activation of the National Guard into Little Rock, Arkansas to force school integration. How's that worked out, everybody? How has that worked out? Just amazing, right? Just the most amazing thing we could possibly have hoped for. It's incredible. At the point of a bayonet, look at these unarmed white men who don't want violence in their schools, protesting against integration, being driven down the street at the point of a bayonet. Look at this guy in the foreground holding his arm. You think he's been pinked with a bayonet already? This was fine. Were they trying to rebel against the entirety of the federal government? Was the president completely unable to enforce any? Did he call out the army first before he called out these National Guardsmen? By the way, a little off topic, but on the notion of schools, in the context of Chicago, here's a list of 30 Illinois schools in the greater Chicago area with spending per student sometimes exceeding $50,000 a year per student. And in all 30 of these schools, there's not a single student who can read at grade level. Good job, Illinois. This worked out really well.